Next up, we're going to talk about legal specialization and board certification. And Dawna Bicknell is here to help us sort of guide us through all that.
Good morning. I am here on behalf of Jack Pelzer. Jack is the chair of the BLSE and sends his regrets for not being able to be here today, and appreciation to Dixie for allowing me to fill his slot. My name is Dawna Bicknell, and I have the distinct privilege of serving as the staff liaison to the BLSE. I've worked for the bar for a number of years. I have a mere 15 minutes, so I want to rush through a lot of information for you, but I want you to know, first of all, who the BLSE is, because everybody associates the BLSE with board certification, and there are other hats that the board, you can't hear me? There are two other hats that the board wears, and that is with respect to the accreditation of continuing legal education, which we cross paths with your sections on that issue daily, and also the enforcer of the continuing legal education requirement and the basic skills course requirement that all new members must take. I want to give you, as I said, a quick overview of the board certification process. I want to conclude with a challenge to you. Paul is always a tough act to follow. I don't have a PowerPoint, but I have two old-fashioned pieces of paper that I want you to pick up at some point, maybe during the break. And I hope it occurs to you that we have common ground and common goals. I want to start with the basics. I want to read to you the mission statement of the BLSE. It sounds rather lofty, but it pretty much succinctly describes what the board's function is. It's the mission of the BLSE to improve the practice of law and the delivery of legal services to the public through the enhancement of technical skills and substantial competence united under the highest standards of professionalism. And in pursuit of that mission, the BLSE oversees the award of certification, evaluates and accredits CLE, and ensures that all Florida bar members comply with the educational requirements established by the Supreme Court of Florida. Board certification is, board-certified lawyers are evaluated for professionalism and tested for expertise. That's our new slogan, and it really succinctly defines what this program is all about. I will tell you that the BLSE gets a lot of credit for board certification, but they are not the workhorses. The committees that really make this process work are the certification committees, and Maria Gonzalez will tell you, Kristen Keene will tell you, Bill Schifino mentioned that the Legislative Committee of the Florida Bar Board of Governors is the hardest working committee on the Board of Governors. I would say that the certification committees are the hardest working committees, standing committees of the Florida Bar. They have the responsibility for reviewing applications. Everybody who applies for board certification fills out an onerous application, and all of that information is reviewed, and you must see that the individual has met the particular standards. There are standards for every single area of certification, and every area of certification has a committee that reviews these applications. In addition to meeting the standards, we also check the disciplinary records of the Florida Bar. We follow up on any professional ethics issues. We look at if the applicant has disclosed to us that there's a malpractice case open. We look at that. We look at show cause orders. We look at to see if there are any contempt proceedings or any instances in which criminal charges involving dishonesty or felonies have been filed. So you can see that there's a very thorough vetting process for applicants that go through this system. Very important to the process is peer review. Applicants are gauged and evaluated based on responses to confidential peer review. We are very pleased that as the result of litigation that occurred a few years ago, we now have an 11th Circuit decision that puts us on fairly solid ground. The court ruled that applicants for board certification and recertification lack a constitutionally protected liberty or property interest in in obtaining board certification, and therefore cannot raise a due process challenge to the confidential peer review. So as a result, we believe that both the judiciary and the bar can freely provide statements to us and candid assessments of our applicants, and we've seen a little bit of change in the responses as a result of that decision. Another responsibility that the committees have, and it's quite daunting, is creating test specifications for the exams. The test specifications really define what the test is designed to cover, and that is the topics, the percentage of coverage of each of the topics, the format, and we also give applicants study suggestions. We have an exam consultant on contract. The BLSE has an exam task force. We have an examination guidelines handbook and also a question and drafting handbook for our committee members so that they're guided in this process, because they're lawyers, they're not test designers, and it's a huge challenge. I want to tell you that review courses are very popular with our prospective examinees. We learned that those who took the exam this past March and those who took the exam in May, there was 72% of the first class that found the review course to be helpful in their preparation for the exam, and 82% signed up for a course for the May exam. The final responsibility of the committees is to recommend revisions to their standards. And this is where you come in as bar sections, because it is important that the certification program reflect what the actual practice involves. Otherwise, you've got standards that aren't attainable, frankly. And a key to the credentialing process is thinking about rebuilding along the way. I know we have so many amendments that go through the Board of Governors as to BLSE policies and BLSE rules, and the reason for this is this program is constantly evolving, and it has to change. It's inevitable that it needs to change so that lawyers can qualify for board certification. The BLSE considers new areas of certification in addition to revisions to proposals, the existing proposals. And one of those that's on track and on its way probably to the Supreme Court in October of this year is juvenile law. It was originally proposed to the BLSE as children's law. It came as a joint proposal from the Public Interest Law section and also the Legal Needs of Children's Committee. And we're expecting that it will be our 25th practice area under this program. Let me tell you where we are right now. I got the question yesterday, and I love this question about what percentage of the bar membership is board certified. If you take the number of members who are eligible to practice law and who have been admitted for 5 years or more, which is the pool of potential applicants, we are at 7.5%. That's very respectable, actually. If you, Texas and California are the other two leading states in the country who offer certification programs, and they are both in their 40th and 41st year. We are in our 32nd year. Texas has a certification pool of about 10% of its eligible members, and California has less than 2%. They have a huge bar membership, as you may know, but they're at less than 2%, and 10 years, they have 10 years on us. As I said to you, I have two old-fashioned paper handouts for you today, and what they are is we've taken the counts from your section membership, and we've compared them to the number of lawyers certified, both overall, all the members certified in your section, and then we have a count of those who are certified with respect to the relevant area of your section. And city, county, and local government law has the highest percentage at 18% of lawyers certified, and appellate practice and tax are tied for second at 17%. My challenge to you is to look at those numbers and to think about whether it would be within your realm, perhaps, to consider making it a goal to increase those percentages within your members. And I ask you this because, obviously, you are the leaders in your practice disciplines, and you are the best equipped to take this on. I would ask that you consider recognizing members of your section who have become board certified. All of you do have websites. We touched on that earlier today, and we looked at the certification information on each of the websites, and we found it was rather hit or miss, and some of the information is out of date. We are happy to provide you with current information. We also would suggest that it would be very simple to merely link with the bar's website so that you have all the current information on the application filing periods and dates of the exams. I would also ask that you maybe consider profiling somebody in your section who has been certified for 20, 25, or 30 years. I think we have such a bank of wisdom in our more seasoned society, citizens of our society, and particularly in the legal profession. And I think it's important to ask these folks, as an example to those who are coming behind them, why they got board certified and what it means to them. You may get varying answers. I know I've heard some different answers. I had a member of a former bar president at the bar convention tell me that after 30 years he'd never had the first client ask him if he were board certified. And to that I respond, nobody needs to know that about you. You don't need board certification, but the program needs you. You're an example to younger lawyers, and you have stepped up and made the commitment to excellence and professionalism in demonstrating your compliance with the requirements. I sometimes find that people don't know where board certification all started, and I wish I had a lot more time today, but I don't. So I can't give you the total history, and I might put you to sleep on that anyway, but it didn't just drop out of the sky 30 years ago. There were a lot of folks that were talking about it, and for example, Burton Young wrote an article as past president of the Florida Bar back in 1973, where he predicted by the year 2000 we will have a profession of certified legal specialists. That was by the year 2000. We started in 1983. Also, Chesterfield Smith, former bar president and ABA president, had this to say. He said that specialization might well give a potential client some assistance in intelligently selecting a lawyer. How brilliant is that? Particularly, that was in 1966, and think about where we are today. Everywhere you turn, there's legal advertising, and the public is bombarded with that without any indication of special knowledge, skills, and proficiency and professionalism, which is what board certification represents. I will tell you, I will confess that I have not always been a believer in this program. I've been involved with it for a long time, and I thought we were putting an awful lot of labor into a process that I sometimes questioned whether there was going to be any result. But I have heard time and time again from lawyers who have been through this process that it made them better. It forced them to study areas of their discipline that they would not normally study to pass the exam. It required them to take advanced CLE. It required them to think twice when they were in a confrontational situation, because peer review can come back to haunt you. And I think it's a great screening device for the public to have a more informed opportunity to make a decision about who to select as their counsel. Former President Scott Hawkins, Bar President Scott Hawkins, referred to board certification as having the potential to be transformative in the practice of law. I think that's a great way to characterize it. Perhaps it will be one lawyer at a time, but this program is still relatively new in compared to the medical profession. It needs to be introduced at a younger level to lawyers, so they're ready for it when their 5 years is up. And I ask you to think about that in terms of your bar section, in terms of enthusiastically perhaps promoting board certification on your website. And if you haven't taken the time to step up to this challenge personally, I ask you to consider to do so. And I thank you for your time today. Yes, maybe. Any questions? This is always scary. Hi, I'm Jennifer Deeds. I have a question.
I am one of the vice chairs of a committee that is seeking section status. How does one go about getting certification approved for the members of that committee/section? Do we go through you in order to begin the process?
I would start with the support of your section or substantive law committee. I think you need to demonstrate that you've got close to 200 members who are going to step up and apply. There has been more of a focus on the critical mass in various areas that I think is important to this program, and it's a concern of the Board of Governors. So we first need to know that there are people out there who are going to qualify, but we're happy to talk with you about that, but talk to your section first.
Okay. Thank you very much.
I'm from the Labor and Employment section. Revision to our certification standards has been a very hot topic. But one of the problems we're having is there seems to be some question with our substantive CLE committee, the Labor Certification Committee, and the section as a whole as to whose initiative this is, where it should come from. I thought I heard you mention that the CLE committees are charged with looking at the issue of revisions. Our committee, the committees has suggested that it is not their function to do that. So I'm trying to get some sense from the bar's perspective, BLSE's perspective, where this initiative should come from, where the input should come from, and how it should be broached to the BLSE.
Thank you for that question. It's an excellent question because it's been interesting. We have both in the labor law section, labor and employment law section, and also in international law, we have some revisions that are being proposed to certification standards that are coming from the section, which has been a little bit different than we've seen in the past. Typically, it is the certification committee that has the responsibility for recommending revisions. So what we've tried to do, obviously, is to get the two groups to work together, because ultimately, both of you need to weigh in on those revisions, because when they get to the Board of Governors, they want to know that there's been comment from the section. They also want to know that there's been approval by the BLSE. So when a certification committee recommends revisions, those typically go to the section for comment before they even go to the BLSE. When a section is proposing amendments, staff-wise, we ask that you get in touch with the members of the certification committee and work with them on reasonable revisions. And I know you've got some on track, and it's good. It's all good.
I have one.
Okay.
This is on behalf of all those who are sort of skeptical about sending in negative comments on their peers. How long are those kept?
We have a retention schedule that requires us to shred, eliminate, destroy an application 1 year after it has been approved. So if the application is approved, it will no longer be in existence after a year. If there is a denial, it may turn into an appeal, and that may put it into a different category. But I will tell you emphatically, and I mean this with all my heart, we do everything we can to protect the confidentiality of those peer review statements. We will not tell an applicant who has sent in a statement. We will not say how many we have received. We will not confirm or deny that we have received one from a certain individual. We do everything to protect those who provide that confidential review to us. And the only bodies that see that peer review are the certification committees and the BLSE. We've had discussions with the Appeals Committee about their right to review on many occasions, but it never got to that level. So the appeal to the Appeals Committee is procedural. They do not see the certification confidential statements of reference, and we get rid of them as quickly as we possibly can, according to the retention schedule.
Thanks.
Sure.
Anyone else? Go, question.
It's really just a comment. I'm glad to hear what you said, because I'm the past chair of the State and Federal
Francine,
Government
I'm sorry,
and
I missed
Administrative
you.
Practice
Yes.
Committee, and we had that question and we didn't know the answer. And I've also had folks who are recertifying and were kind of annoyed that they had to fill out an application that basically asked you for almost all the information that you did on your first application, and the easy response would have been to be able to tell them, well, it's destroyed after a year, and therefore we don't keep that information. So it's good to know that. But I have had the question of what happens to those confidential peer review? Are they just kind of floating around in the records there at the bar? So it's good to know that information.
Can I just address what you said about filling out an application for recertification? Let me just remind everybody that certification is for 5 years, and there are standards for recertification. And if we don't have a process and an application for that, we're not living up to what the rules require of us. So we apologize to those of you who have to go through that process, but it is necessary.
Hello, I get sent a lot of those reviews forms, and you were saying you do your best to keep them confidential. Through discovery, is it possible that the person you're reviewing would be able to get that review? Because sometimes I'm more likely just not to fill out a review than give a negative review.
No, the answer is no. By rule, in the rules regulating the Florida Bar, there is a confidentiality provision within the certification plan that pertains to the exams, the applications. We don't even disclose who has applied for board certification in a given year. And it also protects the confidential statements of review. So we've never been in a position where we were required to disclose those statements. And we have been asked. Thank you.